Hello and thank you for joining us on the Thursday edition of Journalist Hangout. I'm Binga Oreshegun. Today on the program, court sentences Nnamdi Kanu to life imprisonment over terrorism charges, says self-determination must follow constitutional process. A lawyer, Justice Ojieno, will join us for the discussion. Well, I'll be hanging out with Babajide Kolade Otitoju, who is joining us via Zoom, and Adekunle Yusuf. Journalist Hangout starts right now. Now let's begin the conversation. For the self-acclaimed leader of the proscribed indigenous people of Biafra, IPOB, it is the end of a saga, but certainly not the end of the road for him regarding his trial over terrorism charges leveled against him by the federal government. The Federal High Court sitting in Abuja has sentenced Kanu to life imprisonment over terrorism charges. This came after Justice James Omotosho found him guilty of all 7 counts of terrorism charges found against him by the federal government. Delivering the judgment, Justice Omotosho cited prosecution evidence, including video interviews and broadcasts in which Kanu made violent threats against Nigeria and its citizens as the basis for the conviction. The prosecution counsel, Adegboyega Awomolo, SAN, had sprayed the court to hand down the maximum sentence as prescribed by law.
You show me in the name you are wearing the testament. Let them show me the testament. Show me where it says you can break my right. You have the right to appeal after my this is your conversion of the top of the this is the law. Can you excuse me? I cannot excuse let him take out. It's not possible. It is not possible. Take him. You must show me where the Constitution says you have the right to work with the press. You must show me. Excuse him. Show me. Show me where it says so. Show me. Show me where it says so. Excuse him at. Is that how you brought the camera? Is that how you brought them today? Please. You didn't bring it before. You brought it today? Please. Show me where it says you can find me on the law. Show me. Please, get the microphone from him, please. I said, show me. Show me. Excuse me. Show me. Get the microphone from him. No, leave it. Leave it. Leave it. I said, leave it. It's a court of law. I'm under trial. I'm under trial. I have to speak. I'm under trial and I have to speak. Listen to me. Listen to me, please. I'm under trial. I'm under trial. Please use the microphone. I'm under trial. And I must address the court. Please. Wait. No, listen to me. Please. The judge must listen to me. No. Wait. Wait. I'm asking a very simple question. No. Wait. Please.
I mean, the drama that played out in court today.
That's not today. That should be on Monday.
May I refer to Lordship for Section 266 of ABJA? It's not court of law. What you're doing is not law.
Please.
You don't know the law.
Please.
Show me.
Please.
I said, show me. When you have the right to waive my right to hand address. Show me. It's what the Constitution says. Show me. Well, I will rise and come back. You cannot show me. Can you please take him out? I will come back. I rise. Wait, hold on. I'll come back in 5 minutes. Show me where it says you can break my right. Show me the place I'm asking you. Show me. Show me. Which law says you can try me an unwritten law? Show me. You cannot show me. I read the entire file from the time the matter started in 2015. No doubt, the convict has not acted well throughout this period. He has caused delay severally. He caused delay and started crying that he's held unlawfully without trial. And Also, his unruly behavior from the beginning down today, even today, is noticed. However, this court will not consider that in sentencing, as our God himself is merciful. In addition, the death penalty globally is now being frowned upon by the international community. Consequently, and in the interest of justice, I hereby sentence the convicts to life imprisonment for the said counts 1, 4, 5, and 6 instead of death sentence. Life is sacred to God. With respect to count 3, he is hereby sentenced to 20 years imprisonment without no option or fine. For count 7, he is sentenced to 5 years imprisonment without no option or fine. To extend the mercy, I hereby order that the sentence shall run concurrently. And due to the nature of the offenses that borders on terrorism and the attitude, violent nature of the defendants that I have taken judicial notice. The last adjourned date, he was so unruly and expressed violence, even was about to beat a security officer there. This morning, he repeated same. That has been his trait, his attitude. So I have no hesitation in coming to the conclusion that convicts has a tendency of violence. The tendency of violence has not left him. It is based on this that he must be kept in facility that is suitable for his custody, as putting him in Kuje Correctional Center may not be appropriate. And also, I take judicial notice and that for conclusion of the judgment and from the exhibits that I've analyzed in my judgments. Substantially, the convicts made use of computer device like phones in making broadcasts to incite and call for all these atrocities. It is based on that without hesitation, I agree with the counsel to the prosecution that the convicts must not be allowed near any digital device, and if he must be closely monitored by the Office of the National Security Advisor. And also, with the atrocities, the number of killings, and the effect of the acts of the convicts on the people of Southeast, I think it deserved protective custody.
Yes, Nnamdi Kanu was found guilty on all 7 counts of terrorism charges. But, Adekunle, what's next for him right now?
By our laws, he has the right of appeal.
Okay.
So that's next. By our laws, there's nothing he can do other than to go on appeal. And don't forget, before this judgment, I mean, after Monday, trial this week,
yes,
he went to appeal court to stop today's trial. Unfortunately for him, the appeal court has never made any pronouncement or given any order So what happened in court today is absolutely in order.
Okay.
And unfortunately for him, he was given the window of opportunity to defend himself.
Yes, I think the judge was really...
And that was repeatedly hammered on that Nnamdi Kanu, defend yourself. And if you have followed the case, you know, meticulously, you will see in Nnamdi Kanu saying that by the laws of Nigeria, especially the amended, you know, terrorism, you know, act and all of that, that he had no case
to answer.
There should be no charges against him. So I don't know this, and I'm not saying this to judge his own defense team, but what the defense team of Kanu had always put out was that there was no need for the trial. So some will say, why don't you defend this man? Unfortunately for Kanu, again, when you look at his conduct, the prosecution has always made it clear that Nnamdi Kanu is violent, is this and that and that. And they were even looking for, I think, a death sentence. Yeah. But if you watch what transpired, you know, in court on Monday, you will actually pity Nnamdi Kanu. You know, you will see the judge even appealing to him that please comport yourself, that you can actually go on appeal. So when I think he has made his case worse. Whatever, you know, sympathizers or followers that he has, I don't think he has made his case better by his public, you know, his outbursts, his utterances, his blatantly unruly behavior in the court.
But talking about the outburst, the judgment, the drama, you know, that played out, did any of it surprise you?
I didn't expect him to be. If you ask me, those who know me and what I've said consistently, I want a political solution to Nnamdi Kanu, you know, scenario, you know, his travails. But it's beyond me. And those who are in position of power, you know a lot that even the ordinary folks may not know. You get what I'm saying?
Okay.
But what I saw happen lately, repeatedly, as you say on the street, it fought my hand. I felt so sad that why would you behave like this in court? You don't need to. You can't resort to self-help, or you are the accused. You cannot be the defense, you know, lawyer, the judge, the everything. No, it's not possible for you. This is high court. Even if you are sentenced, you can go higher until you go to, you know, the Supreme Court of Nigeria. So there's no need to lose your temper. Whatever may have happened that some of us may not know, I agree with you, but you must compose yourself. He didn't do that. You saw what happened on Monday was so sad.
They said the judge does not have a right, you know, to waive his...
You are not in a position to dictate to the judge. You know,
his right.
In fact, he was dragging the microphone, dragging the scene, dragging everything with even the court officials and the security agents. So that to me was wrong. Whatever the merit of his case, believe me, Kanu may have a very valid case against the prosecution team. But by your own, you know, outburst, by your own conduct, why are you bungling your, you know, your case? You know, judgment is about a lot of things. And in this case, it goes beyond you. It's about Nigeria. We've been battling with a lot of, you know, terrorism cases, banditry and all of that. And the prosecution team is saying you are behind this. There are so many evidences against you, your broadcast, your you know, utterances, many of these things recorded, video, audio, everything. Now, why can't you come on with, you know,
solid
defense against that?
Okay, right about now we have BKO joining us via Zoom. BKO, so good to have you join us on the show. BKO, can you hear me? Okay. All right. Also, right about now, we have a lawyer, Justice Ojieno, will join us, also joining us via Zoom for this discussion. Justice Ojieno, thank you so much for joining us on Journalist Hangout.
It's my pleasure. It's my pleasure.
All right. Nnamdi Kanu has been found guilty, on all 7 counts of terrorism charges. Just like what I asked Adekunle Yusuf, what's next for him?
He has constitutional right to get to the next stage. He has the constitutional right to go to the Court of Appeal. And just like every other matter, eventually, every other generic matter, eventually that starts from any court in this country, whether it's customary, magistracy, and all, they can all write to the Supreme Court, even though some of us have been fighting why all matters from every nook and cranny should end up in the Supreme Court. But that's not the matter for today. We have the option of course, we have sometimes when defendants will be like, oh, in protest, they do not want to explore that option. But that option is open for him. Of course, he's entitled to a copy of that judgment within 7 days because it's a criminal judgment important to the Administration of Criminal Justice Act. And within 3 months, he has to actually file his appeal. Okay. Of course, he can put in what we call a notice of appeal at this time to let the court know that he has intention of going upstairs. And of course, after his notice of appeal, he can start working immediately on transmission of records to the appeal court, and afterwards, of course, file his brief of argument. If even he doesn't file it within the 3-month period, he still has the option of filing what we call a motion for extension of time at the appellate level, taking the leave of the court to file out of time, and the court most likely will grant him.
All right, the judgment. Let's look at the judgment and also the drama of the Kanu's drama in court. Did this come to you as a surprise, though? He was found guilty on all counts, and also the drama that played out in court. Did any of it surprise you?
Okay, for me, with respect to the drama, I've been in high school to my kind of matters like, of course, not anything close to this. This is standing on the same pedestal or on the same level with the famous Awolowo and FRN case, where the whole nation was facing. And we can see that this is about the second time where I'm seeing cameras in the court to tell you how high stakes it is, just like the presidential election petition, and this one is even at the high court level. The cameras are beaming in so that every section of the court, every section of the country are aware that this was exactly what happened. As for whether, with respect to his emotional outburst, I've not seen anything on this field before, but I must confess to you that when defendants see what is before them, what the consequence before them, because the punishment for this essentially is the death penalty, and whether or not the court has a discretion to reduce it to life sentence in most of it, with respect to most of the charges, it's just something that can be taken up by the prosecution on appeal, even though I do not subscribe to that. Just like Mr. Yusuf has said, I am fully and have always been advocating for a political solution. I feel that the ball is out of the court of the Attorney General, pursuant to Section 174 of our Constitution, and cases like the lawyer has said, someone AG Bender said, it is now with the President because it is a federal crime. So we'll move from Section 174 of our Constitution to Section 175 of our Constitution for the President, just like it did a couple of weeks ago for the President to be pleaded with to to give him a blank slate, John Locke blank slate, tabula rasa. We pray that, of course, before the President can consider that, there has to be bargaining. There has to be bargaining. There has to be assurances on the side of all actors that they will abide by probable agreements that may eventually result in such maybe pardon or clemency or commutation as the case may be.
All right. Now, looking at this, okay, how will you describe the evidence, or in fact even the legal reasoning that the court cited in finding Kanu guilty looking at on each of the terrorism charges?
Okay, I must just confess to you that I didn't watch the fully televised session because I was in the middle of a lot. I was very, very, very busy. But with respect to the ones that I heard, we have to remember that it is a one-horse race in a manner of speaking, because the second horse practically threw in the tower in a manner of speaking by not putting in a defense. If I were his lawyer, no matter the quality of defense, I would still have put in a defense, whether it is watery, whether it is fortified, whether it is very, very strong. Because when the matter gets on appeal, I would like for the hands of the appellate court to be very, very full in questioning the conviction. Because one thing must always be reminded of is that the standard for civil cases and standard for criminal cases are different. With respect to civil cases, is preponderance of evidence. If I'm mathematical about it, I would say 51. If you can get 51 over 100, you are home and dry. But with respect to criminal cases, if I have to put it in mathematics, even though I'm not supposed to put it in mathematics for the sake of the layman, it's like 90 over 100. You have to score, prosecution has to score 90 over 100. So my job would be to throw the spanner in the works once in a while, including my defense, in order for the court to see what we call reasonable doubt. And if the court sees reasonable doubt as to whether it did it or not, it will be easy for the trial court and, of course, the appellate court to be able to throw the matter out. But because that is not done, I feel it's a bit harder for the prosecution to be able to uphold the case. Whatever the reasoning of the judge by itself, because it's just one-sided and it's not counterbalanced with the defense of the defendant, the primary defendant in this case, is really not heavily tested as it possibly could have been tested.
All right. You want to ask your question before we go on our break?
Okay. I think I have some questions I want to ask you. When you look at Kanu's, unruly behavior in the court, you will see that it was primarily on the fact that he wanted a bail, and that was not happening, and was it right for Kanu to have behaved that way in the court? Number two, his defense team didn't, provide the kind of defense they were hanging on what they think is that there was no case against him based on amended Terrorism Act. Was that proper, in your own view?
Okay, I'll take the number two first. I think that eventually it started from an orchestra of lawyers to the choir of one person. So we're not able to really, sometimes there are major reasons why we as lawyers, we decide to throw in the towel and decide either not to continue with our representation of the client. And sometimes, in fact, most times it's the client that demands for us to withdraw, maybe because he wants us to take a particular course of action and we were not able to take the particular course of action exactly as we wanted it, or for some other reasons to just tell that we can't continue. Sometimes it's monetary reasons too. So eventually, I do not want to speculate as to the exact reason why a person as monumental as Kanu Agabi-san had to file a motion to withdraw his representation. So, and of course, all the other lawyers. So eventually, it became an orchestra of one person. So the defense team eventually is Mr. Nnamdi Kanu himself. So with respect to whether his outburst or his behavior, I feel that with what I've seen, sometimes when they know the consequences, for example, in life imprisonment and all, they seem to want to behave in a way that is not peculiar to him. If you have done high-profile cases, we see one or sometimes they scream in court, sometimes they shout at the judges and things like that.
All right, Justice Ojeno, just stay with us. Okay, we need to go on this quick break. And when we return, the conversation continues. Don't go away. All right, well, if you just joined us, it's still Journalist Hangout. I still have Adekunle Yusuf right here. Justice Ojeno is also joining us via Zoom. We also have BKO also joining us via Zoom. BKO, I need to apologize. The network We're really, really sorry. But BK, looking at it, Nnamdi Kanu has been found guilty on all 7 count charges. Your submission here?
Well, I think that this was to be expected. Nnamdi Kanu
Okay, I think we're still having...
all works. Wouldn't have expected him, the defendant, the consultant. At a point, he even beat one of his lawyers. And as far as the judge was concerned, he waived his right to
Okay, I think the network is not doing BQ justice right now. But looking at it, you think Nnamdi Kanu actually shot himself in the foot when he let go of his defense team?
He did. Unless you have not been following the cases. I mean, this case, all over. You know, it didn't start with the Tinubu government. It started during Buhari administration. And look at every turn and twist. You will see a Nnamdi Kanu, you know, trying to, I don't want to speak to the merit of the case, but insisting that this is the law. You're not the judge. The president, or let me say the executive, cannot interpret the law. The National Assembly cannot interpret the law.
Just hold that.
It is the judiciary, and the powers are vested in the judges.
Hold that thought. Is BKO back with us now? Okay. I think we're still trying to establish connection with BKO.
I have always been with you.
Okay.
I'm hearing everything you are saying in the studio.
Okay, we could
and
not
it's
hear
very
you.
clear at my end.
We could not hear you. We could not hear you. All right, so
I can hear everything that you are saying.
All right, let's go ahead.
Can you hear me now?
Yeah, I can hear you now.
Yes,
I can hear
clear
you
now.
Very clear now.
Okay. I said that it was natural to expect of the judge. He waived his own rights to defend himself. He fired his lawyers. He converted his lawyers to consultants, and he didn't give them the power to handle his brief. Initially, he said he was going to defend himself, and he listed a host of names like Sanwo-Olu, T.Y. Danjuma, and the rest of them, Nyesom Wike, that they will be witnesses. But the next day they were in court, he said he was no longer going to defend himself. I've never seen this sort of thing in a Nigerian court. A defendant saying to the judge that no court in Nigeria can convict him. A defendant dismissively waiving his rights to defend himself. So what do you expect? Of course, the judge would then use the evidence provided by the prosecution to come to his judgment, and that's what happened. It became a walk in the park for the prosecution because he didn't allow his lawyers to do their job. He even beat one of the lawyers. So that's why it didn't come to me as a surprise. And so much evidence was front-loaded. And that was why on all 7 counts, he was convicted, because the quantum of evidence was there, even in the open. Broadcasts that he had made directing his followers to go after security agents, broadcasts that he made during the NSAS riots, directing people to go and set buildings ablaze, broadcasts that he made affirming his membership of IPOB, which in the judgment handed down by Justice Binta Murtala Nyako in the case between AGF and IPOB, effectively branded IPOB a terrorist organization. So if IPOB had been branded a terrorist organization and the judgment was gazetted, and you still went ahead in broadcasts to identify yourself with that group, identify yourself as a member of that group, definitely you are going to be convicted on one of those counts, which was a membership of a proscribed organization. So you see that nearly on all the cases, on all the counts brought before him, there was no defense. And if he could not muster a defense because he threw away the chance to defend himself, then he left the judge with no option but to convict him. The judge then exercised his powers to to show mercy by sentencing him to life imprisonment instead of the stipulated death penalty. I agree with the judge that in line with global practices, the death penalty is no longer popular, although many countries of the world are still holding on to the death penalty. But the judge then cited a biblical passage. I don't know whether in law it is permitted to cite a biblical passage in coming to a judgment in a matter like that. I'm sure lawyers in the coming days will have a say. Will have a say on what the judge did, citing the Bible, citing a portion of the Bible to then say, okay, I want to show mercy. I'm sentencing you to life imprisonment. But Kanu effectively left the judge with no choice. He provoked everyone and he showed absolutely no remorse. He was very arrogant. I remember Justice Binta Murtala Nyako even begging him to change his dress instead of coming to court in that white dress at all times. But he still didn't listen. He was abusing everybody. Now, only a political solution can get him out of jail, because in my view, because the appeal court and the final court would work based on the evidence laid before the lower court. There is not going to be fresh hearing and all that ceremony at the appeal court. The appeal court will determine whether the judge erred in law in coming to that conviction. That is what the appeal court will look at. Not that the appeal court will start allowing them to bring witnesses, fresh witnesses and all that. So in my view, he has dug himself into a hole that effectively one can predict that he's not going to get out of the hole that he has put himself at the level of appeal and the final court, if the case gets to that point, because that case has been damaged at the Court of First Instance, just as our former CJN, one of our, I think Justice Mustafa said, when prosecution is like building a house, if you build it on a faulty foundation, you are not going to win a case. So I can use that analogy to also argue that Kanu damaged his case at the level of the court of first instance. And in my view, no miracle, no legal miracle can get him out of the quagmire that he has inserted himself.
Okay. All right, let's go to Justice Ojeno. BKO has raised a very, very valid point here. He said the judge actually cited a biblical passage. But as a lawyer, is it appropriate, you know, for court judgment to reference a biblical passage in this context? Is it the right way when it comes to judicial standards?
Okay, we must remember that the judgment that upon the gubernatorial victory of the dancing governor of Osun State too was the judge said a couple of things in that case that formed the basis for that was one of the grounds of appeal to the upper court. And what the court said in that case, the court says in a lot of cases, and that is that an appellate court will only affirm a judge has a right to write his judgment in the way he wishes to write it.
Okay.
And it is for the court of appeal to check whether there is actually a soft to substance. So having said that, let me also give you another direct frontal response. The very case of Donoghue and Stevenson that was decided by Lord Atkins, which is the case where all negligence is based on. The court primarily relies on the story of the Good Samaritan in the Bible, that we are our neighbor's keeper. Okay. So any court can actually, sometimes even in American courts, they rap. You see a judge actually rap. By rap, I mean sing, and there will be rhyme. And at the end of the day, when you go on appeal, the appellate court repeats the same thing. That it's about the substance, it's not about the form.
All right, talking about appeal, what timelines or legal mechanisms exist for appealing such a terrorism conviction in Nigeria?
Okay, it's crime generally, and with respect to crime in criminal cases, it's eventually 3 months. But the certified copy, the law, the Administration of Criminal Justice Act actually certifies that the defendant is entitled to a copy of the judgment within 7 days. So he has the right to file his notice of appeal, I think between 7 to 14 days. Okay. But he has to appeal within 3 months. After the 3 months, if he has not appealed within the 3 months, he has a grace period of bringing a motion, taking the lead of the Court of Appeal for him to file his brief of argument out of time. So if the court finds the affidavit, the fact deposed in the affidavit meritorious, the court can actually grant such a motion.
Okay.
Okay. After Kanu's outburst on Monday, he went to the appeal court, to stop to this, trial. And up to now, nothing has been made or heard from the appeal court. Is that proper? Like maybe an order or anything from the appeal court stopping to this trial? Is that...
Okay. Before the Administration of Justice Act 2015, we had the practice of lawyers who file stay of proceedings. So essentially, the stay of proceedings, some people call it arresting proceedings or arresting a judgment. That's another parlance that we use in our own field. So before 2015. That used to be the practice. We used to delay, and I'm saying we now, including unfortunately the uncultured lawyers among society, take advantage or abuse the criminal procedure by filing such actions. And one of the acts that President Goodluck Jonathan gave us as his parting gift in 2016 was to sign the Administration of Criminal Justice Act into law, and by that law, a court, a lower court, a trial court, in essence, cannot entertain such a motion. So because of that, you can't have a stay of proceedings. With respect to the Court of Appeal, well, I do not want to judge the Court of Appeal and the ruling of the Court of Appeal on this issue, so I will hold my thoughts on that so that I'm not held for being prejudicial to an application before the court.
All right, then we need to go on another quick break, and when we return, the conversation continues. Don't go away.